Good afternoon, everyone. I'm calling to order the August 12th City Commission meeting. We have with us today Reverend Harity from St. Richard's Episcopal Church, who does this for us frequently, and we appreciate it. If you all would remain standing during the invocation for the Pledge of Allegiance, that would be great. Thanks so much.
Let us pray. Dear God, we ask your blessing on all who gather here at the Winter Park City Commission today. We meet to serve the Winter Park community, to use our resources well and wisely, to represent all members of our community fairly, and to make decisions to promote the common good. Help all to recognize their responsibility as individual citizens and as members of a close-knit community. Help all to recognize responsibility to honor the past and look toward the future. Help all to recognize their responsibility and exercise their authority to make right decisions for the welfare and peace of Winter Park. And if you'll indulge me for 1 second, it's the first day of school. Anybody got kids in the Winter Park? Yeah. For the students who are beginning a new school year, give them curious minds, critical thinking skills, the ability to tell right from wrong, and the courage to act with integrity. Help them to learn deep truths about this world and about people so that they may be good citizens for the good of the whole. For our teachers, the brave souls who wake each morning at the crack of dawn to educate other people's children and love them like their own. Keep them from growing weary and cynical. Wrap them in your love, your peace, your wisdom, and your goodness. Help them to see the many ways that their gifts inspire learning, creativity, and compassion. Make sure they get enough support from parents and administrators to keep them going. For the bus drivers, crossing guards, school safety officers, administrators, and aides, bless those who keep our children safe. For cafeteria workers, nurses, and helpers, bless those who help our children stay healthy. For librarians, music and art teachers, counselors, therapists, chaplains, volunteers, administrators, bless those who tend to our children's hearts and souls. This is a new school year. May we all meet this time of year with renewed commitment to our own wisdom, knowledge, curiosity, humility, confidence, and compassion, even when we're not in school. Help us to look toward the outskirts, toward the margins for people in need of compassion and generosity. May we never stop, including those who sit on the edge of the playground. May we never stop sharing our pencils and sandwiches with those in need. May we never cease to see your spirit and goodness in each person we meet. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, Reverend. Thank you for the words, especially about school. Randy, do we have any changes to the agenda?
No, sir.
Okay, we'll look for a motion to approve.
So move.
Second.
All in favor?
Aye.
Opposed? Thank you. I have no report today. We will open the floor to citizen budget comments. Anybody wishing to address the commission on our budget? Now is your time. Ms. Schutz, please.
Thank you. Sorry. Nancy Schutz, 2010 Brandywine Drive. Many of you know I'm like a broken record. Most of you have heard what I want to say. I've been to the coffee talks, I've talked to staff, I've talked to advisory boards, but I haven't gotten any answers. I apologize if I'm behind the knowledge base, but the last 6 weeks I haven't attended budget meetings or the transportation meetings. The transportation minutes are behind. My main focus here is that I think we need to make sure in our budget that we have added money for public works, for worker bees. I'm excited that we're going to now focus on getting a transportation person and focus some on all of our different types of transportation needs. However, as I have looked at all these things for the last 3 or 4 months, as many of you know, I have some of my own pet peeves, but they're only one of many. But as I've done this, I keep finding documents that are 5, 10 years old that said we're going to do this, but they still haven't been addressed. So we have different documents that people have said we need to do these things, but they haven't been done. We've been focusing on the big things like Denning, which I know is very important, but then we have little things like the safety of the bike paths. With your new bike policy, my little example is the Glen Ridge from Laurel Road to Winter Park Road. You put a 3-foot square fix on the brick road last winter that I found out was not done in-house. It was done out of house by a shoddy construction group that did a bad job. Now we've got more holes. What have I got, 1 minute? So now we have more holes. Then I read recently that we need bricks. How about if we take the bricks off of the 2.5 blocks and then safely asphalt it for the bikes? Everybody knows that the bike path over in that area there's no bike path. It's very dangerous. I even suggested at somebody's coffee talk a couple months ago that we needed to have someone just go in and trim the grass on the part that is already a bike path before you get to the brick road. That has not been done. So there are a lot of little things. So I think we need to focus on some of the little things for the safety of our community, not just my one little thing that is my pet peeve, but make sure we have money in the budget so that whoever pulls the strings on these projects, we can do the things that we need to do for the infrastructure for our community.
Thank you, Ms. Schatz. Anyone else? Thank you. We'll close the floor to public comment on the budget. Ms. Schatz, I would, if you would put a list together of the things that you've noticed, we'd be happy to take a peek at those and make sure if there are items that the city management can get on that need to be happening. Okay, thank you.
I actually have already sent emails a couple months ago,
Okay.
but unfortunately I didn't address just one item. I addressed 2 or 3, which I know is not.
I'll just bullet point them. We'll get to them. Thank you. Okay, Randy, city manager's report.
Yep, speaking of budget, your budget spreadsheets are due by Friday. That's the annual spreadsheet that any changes you'd like to see made to the budget, if you get those into us, we'll compile them and get them out to all the commissioners. With that, I'd be glad to answer any questions.
That's this Friday, right?
That's this Friday. Any questions for the city manager?
I had a couple, Mr. Mayor.
Sure, Mr. Seidel.
At my coffee talk, one of the items that came up, Randy, and I briefly chatted with you about this week, was the mailboxes and the location of the mailboxes. And I think everyone received a document, I believe, and I actually did not get that document, or I got it and it was misplaced at my house, the one that Rod Sword put together, which is highly possible with all the traveling and my girls cleaning the house and me not knowing where things get put. So I do not have a copy of it, but it was interesting when, and you had indicated just from the aesthetic point of not having the mailboxes adjacent to the roadway. And so, you know, one of the thoughts I had is, I don't know if you've ever had conversations with the postmaster about supplementing so that we could expand that or keep that. Is that something the city was interested in doing? Because it made a lot of sense to me from an aesthetic perspective that it does really look much nicer, and it may be worth the citizens of the city to do something. That's all. So it was interesting that all that came up, but that was kind of, I didn't know what a next step was, but I would like if someone has an extra copy of that document, or to get a copy to me so I can read it.
I have a copy, I can get you a copy.
Okay, thank you.
So you're not asking for anything to happen other than you just get a copy of it to review it right now?
Correct. I would like to see the document, and then I just kind of had the idea that maybe there is something we can do about the mailboxes, and I thought it was a pretty interesting, like I didn't really fully understand until I talked to Randy about it, and he explained some of these things to me.
It's a topic that Mr. Seward's very passionate about and brings it back occasionally to us.
We did have extensive conversation about this. It's got to have been before you came on the commission. You all remember that. So we did look into this and look at any possibilities. It's probably been 6 years ago.
Okay. So anyway, once I read it, I may come back with something and have more conversation then.
Okay, Commissioner Cooper.
Randy, do you remember the results of those conversations? I do remember us pursuing it, and
Sure. As I recall, we adopted an ordinance saying that you're not supposed to put your mailbox, I think it wasn't that specific, it said anything over so tall in the right of way, unless you're already have your mailbox there, because that's the way it was established years ago. And so what Mr. Sward's interest is the post office from time to time either, in his mind, tricks people into putting their post office, their mailbox out at the street when it was previously at the house. And under postal regulations, if it's ever at the street, you lose the right to have it at your house. And so if they ever trick you into moving it there, then they've got you. Whereas, if it stays at your house, they can't make you move it. And so what our ordinance unfortunately did was put the resident in the middle. We would tell them, you need to go, you need to remove that post office box, and then they would put it back at the house, and the post office say, we're not going to deliver your mail. And so we were putting our resident in the middle, and we decided enforcing our ordinance was not fair to the resident. So we have not been actively enforcing that ordinance because of that. It was our residents couldn't get their mail delivered. And so that's kind of where we stand today. He mentioned the other day that we have a new postmaster that's tricking people again. I don't know if that's the case. I don't have any evidence of that, but he goes around and he sees a lot of these, and so that's kind of where we stand on it.
so it sounds like perhaps we have an ordinance that needs to be repealed or somehow fixed so that we can actually enforce it. I actually was one of the people that the post office told that I could not use my mailbox at my door, that I had to put it on the street. So I do have some sympathy for that. But I agree with Greg, it's worth taking a look at. I want to be cautious as we do that, but I would like to take a look at it.
Randy, I think we have 3 nods up here to at least get the ordinance back out to us so we can take a peek at it before we take further action.
Yes, sir.
Okay?
Yeah.
Mr. Seidel.
Mr. Mayor, just if we're going to be talking to the post office about the post office, do we bring these up together as one in those conversations, or is it something completely, we will keep it separate? So anyway, just a thought there. My other question for, I've got
Thank you.
I've got at least 2 no's, do I have a third no?
A big no.
I support Sarah on combining the two discussions.
Let's get a little information first. Go ahead, Mr. Seidel, you still have the floor.
Okay, fair enough. But I did have a conversation with Mr. Sward, and so I did want to follow up, because I have to call him when I read it, and I haven't been able to find it yet, so I do have his phone number here. The other item I wanted to ask about, Randy, was, and I'm not 100% certain on this, but when Rollins came to us about building their new dorm, they talked about staging that construction process, and so that they could still have some dorm rooms on campus. And my understanding is they didn't stage it, and they're doing it all at the same time now. I could be wrong, but that's kind of what I see. The building's not there, and I thought I recall a conversation of that. But if they are doing that, then, there'll be more students displaced, and is there coordination between the city and Rollins on, I'm expecting there would be more cars as well, and parking, and so does the parking garage take care of that? And can they make sure that the extra students are parking in the parking garage and not throughout the other areas? So those are some things I just wanted to see if the city could coordinate with that, find out what the status is, and, because that's the side of town I live on, let the residents know what's going on. I've had a few people mention it to me. So.
And you might want to find out what they've actually done, because I've heard what they've done, and I don't think it's going to be a problem.
Okay, yeah, no, that's what I'm asking.
I don't want to be the one to tell you, we'll let somebody else do it. I just know what I heard they did to try to accommodate all the students while they're displaced.
Well, that's why I asked the city manager.
Okay?
Okay, that's
You
it.
can certainly do that anytime. Commissioner Sprinkle.
Okay, so the last time we were together, Randy told us about the problem that we have at our feet right now, which is at the dais, we have termites. And so he brought that up and suggested that we rebuild the dais. And I didn't have time to think about it before, but I've done a lot of reading about gathering people together, and I'm just curious to see if there's anybody who has any interest in creating a dais that's not above everybody else, but maybe more down at the level of the rest of the people that come in here. And I just am curious about that because I know the message we send when we sit up here. I had a story one time, you all remember when Mayor Strong was the mayor, and I had Young Hope in my kindergarten class, and he came into class one day and he put a chair up on top of the table. I said, "What are you doing, Hope?" And he said, "I'm playing Judge Sprinkle." And he knew already at his age of 5 that he put a chair on the table, he could be the judge. And we all feel that way at times, and that's really not what we are. So I just wanted to bring up the fact that if there's anybody that has any interest in it, instead of just building it back the way it is, I just thought it might behoove us to think about looking at another way of doing business here in the chambers.
I don't see it that way. I know some have said that, but I think I've sat out there and I've never felt that the people up here sit above the residents. We're reminded continually that the residents are primary here. It helps me to sit a little bit higher so I can look out and see and interact, actually. So I can actually see George and Jeff back there, and Craig, and Parsham's trying to hide, but I can see him. So it actually helps.
You know, we could do stadium seating out there. And
Yeah. So
I understand you can't do that. I'm just bringing it forward because it's something that's important to me, and it's in line with the way I think, and it's in line with the way I rule. So I'm wanting to bring it forward to see if anybody else was interested.
I think it sounds like more of a problem for Judge Sprinkle sitting up there in his
No, I don't think it was a problem for him.
That's true.
Does that at home sometimes.
Anybody else want to weigh in?
All right, well, I thought I'd bring it forward just to see.
Well, if something could be done, a little less imposing design, because if that's kind of what you're getting at, that, architecturally be made less imposing, I don't know what the new one's gonna look like. We're not replacing in kind, right?
Guys, let's not get into a design of dais here or what's imposing or not. The staff already has direction to move forward and clean this up. Unless there's something specific or general you'd like to hit them with, let's try to move on to
I thought
policy
less
setters and
imposing
not
was
dais
general.
designers. Okay, great. Any other questions for the city manager? Nope. Okay, Mr. City Attorney.
Just one, yes, just one item. The Harmon Champion Circle litigation mediation is scheduled for August 16th. Randy will be there with the Insurance Defense Council. I think the city is sort of a minor player in this litigation, but we're been asked to participate. If anything that would affect the city, if there's a proposed settlement agreement that affects the city's rights at all or obligations, then of course that would come back to you for consideration. So I just want to let you know that's what's going on in that case.
Thank you. Questions for the city attorney? Mr. Seidel.
Yeah, no, thank you. And for those who don't know, I got involved in this a couple years ago and tried to get the people not to keep fighting, because I think it's been about 2 years and 3 months and nothing's changed hands on the property. They were trying to sell and nothing's moved. So instead of mediating, those folks are now, instead of mediating amongst themselves, they've been fighting through the attorneys for a couple years. But I want to let everybody know that Glenna, who's the one lady, has called me several times, and I've asked her, will you have an attorney that can give you that advice? And she's like, yes. I'm like, well, that's who you need to talk to, not me. I shouldn't be giving you this kind of advice. Right, that's why I'm just letting everybody know, but I have pointed, like she's asked about right-of-way, and I said, we can always talk to Orange County about right-of-way, and those are, but I suggest you get with the city and ask the city questions, and they ought to be able to answer them. Bronze, I thought I sent her to you the last conversation that I had with her, so talk to Bronze about it. So anyway, this is something that's finally come to the mediation, but they do have all the property owners involved in this meeting, because there's actually 4 or 3 associated with the circle, plus Glenna across the street, correct?
I believe all the parties that have been named in the lawsuit are participating in the mediation.
Okay.
Thank
Any other
you.
questions for the?
If we're interested in hearing that conversation, what time on the 16th is it?
I believe that.
Would you get that out to us, Dan?
Yes, I
If
can
you
do
don't know it
that.
specifically, just get it out to us. Thank you. Okay, let's move on. We'll take citizen comments close to the 5 o'clock hour. Consent agenda, what say you folks?
I'd like to pull 10A.
10A is pulled. Anybody else?
I'll move the rest.
I'll second the rest.
Okay, we've got 10B and C. Let's open the floor to public comment. Anybody wishing to address the commission on items 10B and C? Now is your time. Seeing none, we'll close the floor to public comment. All in favor?
Aye.
Opposed? Thank you. Ms. Cooper, 10A, yours.
Yes, on 10A, on page 15 of the agenda packet, about halfway down the page, this is on the discussion of the Mayflower. And it said that Commissioner Cooper addressed the prior preliminary approval and showed the zoning code provisions outlining that the commission has the right to ask for transportation improvements such as the bike path. And in the minutes, it says, or the commission could just require that Mayflower go back to their original plan. I just would like the record to be clear that that wasn't just a haphazard statement. What I actually said that it was that because the Mayflower submission included substantial changes from the preliminary approval, the commission could require that the Mayflower go back to the original plan. I just wanted the intent to be clear. And so that's, would be my motion.
We hate rewriting minutes.
I understand, but that one
If they're-
sounds like a
unless-
very
unless they're-
flippant comment, and it was
Unless
not.
they're factually
Thank you.
correct.
They
That's what
are.
we kinda, and
Yeah.
I don't see the factually incorrect. I think it's just I understand what you're trying to say, but I think that's really just a,
Okay, well, I just need 3 commissioners
That's true.
nodding, so I appreciate it. if you
sure, anybody else?
Don't agree.
Yeah, no, I would, if it's not stated elsewhere in the minutes, I think
It's
it needs
not.
to be stated
Thank you.
within the minutes. So I would
Okay.
second that.
Okay, so let's open up the floor to public comment. Anybody wishing to address the commission on this item? Okay, seeing none, we'll close the floor to public comment. We have 2 on that. So Cindy, would you like to call that to the change, or do you want to just get a third nod? I'm happy to get a third nod if there's a third nod, rather than call it to an official vote. Mr. Weaver, is that a nod to make the change as proposed? Okay,
Thank you
fine.
very much.
So let's make that change, if you wouldn't mind, Cindy. With that, all in favor on 10A with the amendment, with the change that suggested by Commissioner Cooper? All in favor, say aye.
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 Opposed?
No.
No? Thank you.
Thank you very much.
And no, I just don't change minutes. It's just
Yeah,
not in
that's-
my
Again, it's
makeup.
not that, I agree. It's got nothing to do with that. Okay, public hearings, we have 12A. Mr. Langley, would you please read this? This is on second reading, folks.
Ordinance number blank dash 20, an ordinance of the city of Winter Park, Florida, vacating and abandoning a portion of the utility easement that encumbers the property located at 1691 Chestnut Avenue, described as Lot 1, Block 1, Lake Knowles Terrace, according to the plat thereof, as recorded in Plat Book K, pages 4 of the public records of Orange County, more fully described in Exhibit A, providing for conflicts, recording, and an effective date.
Okay, we're on second reading here, folks.
I'll move it.
Second.
Okay, I heard Commissioner Cooper first. Let's open up the floor to public comment, and we wish to address the commission on item 12A. Now is your time. Seeing none, we'll close the floor to public comment. Cindy, would you please read the roll, or Renee, who's reading the roll on me here?
I'll do it.
All right.
Well, maybe. Commissioner Seidel?
Yes.
Commissioner Sprinkle?
Yes.
Commissioner Cooper?
Yes?
Commissioner Weaver?
Yes.
Mayor Leary?
Yes, thank you. 12B, Mr. Langley.
Ordinance number blank, an ordinance of the city of Winter Park, Florida, authorizing the conveyance of the city-owned property located at 2600 Lee Road, described as Exhibit A and pursuant to the contract attached hereto as Exhibit B, providing for conflicts and an effective date.
Okay, we're on second reading here as well, folks.
I'll move it.
Okay, do we have a second?
I'll second.
Okay, for discussion? No, let's open up the floor to public comment. Anybody wish to address the commission on item 12B, now's your time. Seeing none, we'll close the floor to public comment. Cindy, would you please read the roll?
Commissioner Seidel?
Yes.
Commissioner Sprinkle?
Yes.
Commissioner Cooper?
No?
Commissioner Weaver?
No.
Mayor Leary?
Yes, thank you. Item 12C, Mr. Wiggins. And folks, I want to be very clear on what we're voting on here, so let's try to keep this very focused on what is being asked of us today. Mr. Wiggins.
Well, you don't often see my face up here, fortunately, but
George, because of the tiered seating, I see it out there every
very good.
Not see you, we see you.
You see me. Well, that's good to hear. What you have before you today is an of a determination or an interpretation of the Winter Park zoning code with regard to how you determine the lakefront setback for a new residence. And what I want to make clear at the outset, that this is not an appeal of a decision of the Planning and Zoning Board over a specific property, but it's merely an appeal of how we applied the code and interpretation of the code reads.
Is it fair to say it's an appeal of staff's interpretation?
Yes,
Thank
it's
you.
an appeal of staff's interpretation, and it has to do with, again, the determination of a lakefront setback with regard to including an accessory structure next door to a property or in line with properties that are being used to determine the lakefront process. The appeal took place, first of all, at the Planning and Zoning Board meeting that occurred on July 19th. Their decision was to uphold the interpretation that we use. It was a unanimous decision at that point in time. The appeal decided to further the appeal before you all, the City Commission. Again, background on the appeal is that the Planning and Zoning Board did approve a new one-story house at 1204 North Park Avenue, and in the determination of what the lakefront setback was for that new home, staff utilized the adjacent properties as required by the code. It requires that you look at the adjacent properties within 200 feet. In this particular case, there were no properties to the north, there were properties to the south. They used the appropriate properties to the south to determine the lakefront setback. The setback turned out to be 68 feet. And the adjacent property, there was an accessory structure that was very close to the property, to the lakefront. That average was included, and the code seems to indicate that you do include that accessory structure, and it's pointed out in the code, which I can go into further, or I'll turn it over to Dan Langley in just a minute to go over further, but that's the essence of the appeal. Party appealing this is stating that there's another provision at the beginning of the zoning code that prohibits you from using a non-conforming structure in counting the number for the lakefront setback. However, the basis of our interpretation is the fact that there is a more specific provision in the code that was put in the code long after the original provision that's being used against our interpretation, that very clearly tells you how to deal with the measurement of a lakefront setback. And that provision, again, states the Planning and Zoning Board the authority to approve a lakefront setback up to within 50 feet of the lakefront. Even if the average turns out to be less than 50 feet, P&Z is empowered to do that, both to move a house closer, or they can require it to be further away than the 50-foot setback. And that provision is in the code and covered quite exclusively. Again, I wanted to point out that this, I need to answer further questions, but again, this is not an appeal of the planning and zoning decision with regard to a house at 1204 or 1202 North Park Avenue with regard to the lakefront setback, but it's appeal of our determination.
This is an interpretation that was supported by city legal, correct?
Correct.
Okay.
And with
Okay,
that,
any-
I'll turn it over to Dan Langley to
Dan,
further.
any quick thoughts
explain.
before we just open this up for comments from the dais?
I just want to echo the comments that we have a particular provision that we're dealing with. It's the provision that allows interpretations of Georgia's interpretations of the code, appeals to initially the Planning and Zoning Board and then to the Commission. And that's what's here today. And what's before you is actually what's in Georgia's letter that's in your agenda packet. That's his interpretation that's being appealed. And so the crux of it is whether or not the provision in the lake side or lakefront approval code 58-87 that provides that when you calculate a setback for structures, lakefront lots, it says the setback from the lake's ordinary high water elevation for single family and duplex buildings and any other accessory structures on those properties other than boathouses, docks, over the water gazebos, or retaining walls shall be the average of, oops. The average established by the adjacent lakefront properties within 200 feet of the subject property or 50 feet, whichever is greater. And then it goes on and say that also the Planning and Zoning Commission shall have the authority to approve a lakefront and canal front setback less than that average to a minimum of 50 feet. So there's a barrier there that says that they can approve it for something other than that average, provided it doesn't go lower than 50 feet. So I think the arguments that are being raised in the appeal are concerning whether you count accessory structures in that average calculation. And I think there are two arguments sort of being made. One is you don't count any non-conforming accessory structures, and two, you don't, I believe the other argument is you don't count any accessory structures. The code 58-87 actually talks about structures in the context of lakefront reviews, including accessory structures, and that provision I just read refers to other properties, principal structures and accessory structures, and you look at the average established by the adjacent within 200 feet. So I believe those are that's what's being appealed, and Ms. Wilson's letter is also in your agenda packet. And this is what she's claiming to be the erroneous interpretation that's being appealed. The Planning and Zoning Board Commission did uphold Georgia's interpretation. I did look at it, and I believe it is a reasonable interpretation. This commission has the authority to overturn the interpretation and substitute its judgment for the interpretation. You have the authority to uphold the interpretation. You have the authority to reject it, although if you do reject it, I would recommend that you do articulate a substitute for the interpretation, because we need guidance on this provision if you disagree with the opinion in any way. And again, there is litigation that's pending regarding the property that's cited in this particular appeal letter. However, that development order that's referenced in this letter is not subject to review by the commission, and it's not the subject matter today. That is a final decision of the Planning and Zoning Board. This commission gave it the authority to make those decisions, and it can only be overturned by a court of law or a settlement agreement by the parties involved.
Thank you, Mr. Langley. Folks, I'd just like to comment any disclosures on communications with the parties in this. Mr. Seidel.
I had met with the attorney and the property owner for the lot with the setback that's in question.
Mr. Sprinkle?
Did I say that right?
Yes, I've met with both and walked the property.
Ms. Cooper?
I have spoken to the attorney for the current property owner. I have spoken
I'm sorry,
with
there's two property owners
I'm
here, so
sorry.
that's okay.
the smaller lot. I have spoken with the attorney for Mr. Cohen. I have spoken with Mr. Cohen. I have spoken with Paul Missingman, the owner of the larger lot, and I have spoken with two of the neighbors that have contacted me,
Thank you, Mr. Weaver.
and staff.
I'm going to recuse myself from the to avoid the perception of bias on the issue. I own a non-conforming lakefront structure and would like to recuse myself.
Mr. Langley, have you had conversation with Mr. Weaver about the recusal?
Mr. Hardiman, I have approved that
Okay.
due to the appearance of a conflict of interest and or bias or potential bias. This is
have
We
lakefront
all-
property, and I have no
Hold
idea.
on one second. I think we need to, there's appearance and then there's conflict and then there's appearance.
I believe he's wanting to recuse himself on both, based on his circumstances.
Okay, can we take 5 minutes, folks? Okay, folks, we're back in session. What I will offer up is if there's any other commission members who feel that they too could possibly need to recuse themselves for the possible appearance of a conflict.
What do you mean?
Well, what
I mean,
does
come on,
the-
Mr. Mayor,
What is that
there-
supposed to mean?
I know we all own lakefront lots here, but,
No, we don't.
well,
Sorry.
4 of us do.
Didn't make it.
So, the
I'm not
issue
really
is the fact
lakefront.
that
I own both sides of the street.
this calculation is based on whether or not a non-conforming structure should be used, and I have one of those on my property. I didn't build it, it was there when I bought it, and it would cause the same kind of conflict should one of my neighbors decide to do something different. It doesn't fit the list like a seawall or a dock or any of those things, so it is a unique situation that not all of us here share.
It's truly, but it's the usage of appear to be a conflict that's the challenge here. So
Is,
I'm
here,
really.
I really do have a question here, a legal question.
we can also
I-
take these off. We can also take these off the dais.
No, I don't mind just doing it and
Okay.
getting it out here and getting it over with. I own a lakefront lot. Of the people up here, I'm probably the only person that owns a lakefront lot where the lake is in my backyard. Is that true? The lake's in my backyard. And I've never gone out and measured how far my house is from the lake. So I cannot tell you that. If somebody can go on the Orange County Property Assessor's website and tell me if I have a conflict, if we are going to assume that non-conforming setbacks create a conflict, then I need to ask staff, and Bronx is doing it for me now. I would like to know if my house sits far enough back from the high water line, because I don't know. And I don't want to get into a contest about this. I want to do what is right within the law. I have very strong opinions about this, and I'd love to share them,
Yeah,
but I want to do
Yeah,
what's right.
If I recall, Sarah, from our class you and I had on ethics the other day, they said if this can affect a lot of people, then it's not a conflict. But if it only affects a couple people, that's where the conflict,
class.
right.
Mr.
So
Langley has
I
a
would
comment.
say there's a lot of lakefront owners.
Mr. City Attorney.
Thank you. So the voting conflicts law says that if there is or appears to be a voting conflict, and a voting conflict is something that may arise to your financial gain or loss, or that of a relative, a business associate or partner, that you can recuse yourself, or actually you shall. There's also a matter of you can recuse yourself if in a quasi-judicial context you feel that you cannot be impartial and you may have a bias. If something is not special to you, a gain or loss, then it is not a voting conflict. There may be an appearance of one, and the statute does give wiggle room for individual commissioners to make a decision on whether they want to recuse if there's an appearance of a voting conflict. There is some guidance from the ethics, the Commission on Ethics on the 2% rule that you talked about. It is guidance that if a decision of this commission affects more than, if you're in a member of a group of class and you're only affected by 2% or less, then you don't have a special gain or loss. So still, a commissioner, if
Don't you also have to have some pending event if you're,
well, it shouldn't be it doesn't have to, it shouldn't be speculative. So some speculative potential situation in the future doesn't present a voting conflict.
okay.
However-
And I've been advised by staff right now that my house sits far enough back from the high water line that I have no non-conforming structure or lot. Thank you.
So I have heartburn again because most of us put in something non-conforming because the rules were changed by people up here after our houses were built, okay? So I had a house not too long ago that I just sold that is not conforming by any stretch of the imagination because it didn't meet the setbacks we have today. So when they rebuild a house there, it does have to meet the new setbacks. So it's not unusual for the people in Winter Park to live in non-conforming homes because that's how they were built. They conformed at the time they were built. So that's my problem, is us calling something non-conforming, which it might be today, but it wasn't when it was created.
So, Mr. Seidel, I would just say one thing, though, very quickly. This is Mr. Weaver's option to recuse. He has not been guided to, this was a decision he's made, so just be clear on that.
Yeah, no, thank you,
Mr.
Mr. Mayor. I just wanted to share an example, Commissioner Weaver, because I own my business, I have to report on a lot of things that come forward. When I was building my house, and I had a substantial contract with my contractor, he came before the commission for a lot split. I recused myself because I had a substantial contract with that person. That person recently came before the commission, his company again, to do a lot split. I did not recuse myself because my house is done, I no longer have that contract. So there's a time when it is active that you should recuse, and there's a time when nothing's going on that would really be a conflict right now. So I just wanted to share that with you, because I take this very seriously with the conflicts, and that's the judgment that I used on this.
Okay, so do we have 4? And if we'd like to move forward, we will move forward. The chair will certainly entertain a motion to table until you all, if there are some concerns amongst any individual members of this commission.
Can we initiate discussion?
I would certainly entertain. I was giving the opportunity for a table. Seeing none, we will open up the floor, or we will open up the dais for discussion. Questions from staff, to staff. First, Commissioner Cooper, I saw your finger there.
No. Curious as to whether we have I don't know the process for this. Does the applicant present?
We can have the applicant come forward.
Yes,
if
Ms.
we'd like.
Wilson has an opportunity, then it is public hearing, other folks.
Hold
have
on
op-
one second, folks, but again, let me just take a step back. I'm offering the dais the opportunity to speak to staff who just stepped back. So once those questions are answered, I'll certainly allow we'll allow both parties to come to the podium to speak. Do you have a question for staff, Commissioner?
I do.
Okay.
My question involves the application of, I guess it's 58, is it 5894? As I looked at the code and discussed this with staff, no place in our code does it specifically say that the city commission cannot overturn the ruling of P&Z, and we're making that determination based on the absence of that language. And my issue is that I was here when we changed the name of P&Z from a commission to an advisory board, and we also took away the requirement that the commission have a supermajority vote in order to overturn P&Z's decisions at that time.
It's in conflict with the charter, so yes, that's
Right,
why we did that.
but what I'm saying is all of that was a degradation of the authority of the local planning agency, and I thought that that was intentional, and I thought that the absence of that language in our code was also intentional, because when I went to the Board of Adjustments, it very clearly says in the Board of Adjustments that that must go to circuit court. So my question is about the application of 5894 and whether this commission has the authority to overturn the decision of the P&Z. That's my question to legal, is based on the fact that it's clear about the Board of Adjustments, it's quiet in the code, and we changed the code to take away the supermajority and stop calling them a commission and started calling them an advisory board. Are we all comfortable that we do not have a right to rule on the actual decision?
Mr. Langley.
Yes, so you referred to 58-94. That's the provision that we're here on today. That's the appeal of George's interpretation. Is that what you're referring to?
Because if you read 5894, what it says is that we have the option of either upholding George's interpretation, upholding P&Z's interpretation, or replacing their decisions with our decision. And so what I'm trying to make sure of is that we don't have the right to overturn the actual decision. I hear you saying that we only have the right to recommend changes to the code, and I want to make sure I'm not...
Interpretation of the code.
Right, interpretation of the code.
But he didn't say, that's what's just being brought forward
I think
tonight.
I need to back up and explain this a little better then. So what you have the authority to do today is with George's interpretation letter is that you can the board, the Planning and Zoning Board upheld that interpretation. You have the ability to uphold the interpretation that the Planning and Zoning Board also upheld. You have the ability to reject that interpretation and grant the appeal of Ms. Wilson's client and substitute a contrary interpretation. This provision 58-94 is the provision at play here today. There's another provision that I was referring to that involves the process where the Planning and Zoning Board actually considers an application from a particular property or property owner and has the authority in that section to grant, deny, or grant with conditions approvals of structures on lakes or on lakefront lots.
Right, and it's silent as to whether that can be appealed to the commission, and it's silent as to whether that has to go to circuit court. Correct.
Well, that provision doesn't provide for any appeal, but as a matter of law, once a board, the city board, makes a final decision that's constitutional, the courts have concluded that that's subject to a petition for writ of certiorari in circuit court.
Okay.
There's nothing in that
So
provision that says that those can be appealed to internally to the city, to the commission, or any other board of the city. I read that as when it says that the Planning and Zoning Board has the authority to grant, deny, or grant with conditions something before a building permit is issued, and it doesn't speak to any other way of appealing it. I just read that as final because it doesn't provide for any other way of dealing with it.
Okay.
Okay?
It's
Yes, I think
silent, in
I
other
understand.
words, because it intended to be silent.
Well, that was my point, is
I
that
mean-
perhaps it was silent because it was
Okay.
intended to be silent because the Board of Adjustments is not silent. It says it must go to circuit court.
Different responsibilities. Commissioner Seidel, I'm
I
sorry,
got it.
Commissioner Cooper, you yield? Commissioner Seidel, for staff, before we have the parties.
Yes, I had a couple questions for and they're really not questions relating to the code here, but I think it's important we understand Mr. Wiggins' background because
I don't think we need to, we're really, Commissioner Seidel, I appreciate that. Mr. Wiggins and everyone that stands up there from the city is certainly capable to defend their position, but I really would like to try to stay focused on the issue at hand here, and if you've got questions regarding the interpretation, that would be, certainly we'll take those. No? Thank you. Okay, so let's hear from, I'm not sure to call it applicant or one of the parties.
I think I am the appellant.
The appellant.
And,
Thank you. I've never called you that before, Ms. Wilson. The appellant. You have the floor.
My name is Rebecca Wilson. I'm here on behalf of the property owners at 1202. I'm sorry, losing my train of thought. Park Avenue, North Park Avenue. Just a couple of things. You're correct. We are here on an appeal of an interpretation. The only two parties to that appeal are the city and me on behalf of my client. I just to address Commissioner Cooper's concerns, I tend to agree with you that appeals should be able to come here of planning and zoning. That is not your city attorney's interpretation of that code provision, so in the future maybe that needs to be changed, but our only relief from that development order that planning and zoning gave is to circuit court. There is a pending action in circuit court, and I completely agree with Dan that we are not here tonight expecting that this board can overturn the decision that was made. But I do think that it's important to bring to you all how the code is being interpreted and what those impacts are on planning and zoning's lakefront review. Because in the 15 years I've watched your planning and zoning board, there are a significant number of homes on the lakes being torn down right now and rebuilt. So it's an important time to make that decision. A couple other clarifications. We are not appealing, as Dan suggested, that statement that you don't count any other structures on the waterfront properties. We are not appealing that. We do agree that conforming structures should be counted. And then also, we are not appealing the statement that planning and zoning can, for good cause shown, increase or decrease the setbacks. We're not appealing that. What we are appealing is where the code requires that your staff determine what that average setback is. And that then goes to the Planning and Zoning Board. And usually, and we've seen the Planning and Zoning Board let people move closer to the lake, for example, when they're saving a tree in the front yard or a side yard. So we're not appealing that at all. And it's actually very simple. This is your city code. Chapter 58 is your land development code. It's candidly the only chapter I've ever read in your city code. And Article 3 deals with zoning. And so the sections in Article 3 are section 5861 through 5893. So all of those are part of Article 3. And so 5864A1 states, it is the intent of this article, so Article 3, that nonconformities shall not be enlarged upon, expanded, or extended, nor be used as grounds for adding other structures or to allow uses prohibited elsewhere in the same district. So we believe that in this instance, the staff is interpreting this in a manner which is in direct conflict with this. So in the instance I'm going to show you theoretically where it happened, a non-conforming structure was used just for that. So let's look at the lakefront review sections. So 5887D5, the 5 is what the lakefront lot that is being redeveloped. Okay, that 5 applies to those people, that structures on lakefront lots require approval of the Planning and Zoning Board prior to getting a building permits. As conditions necessitate, the Planning and Zoning may impose increased setbacks in concert with their waterfront review or conditional use authority as necessary to accomplish the objectives of this section. Structures in this context, in paragraph 5, shall also include lots, parking lots, driveways, swimming pools, cabanas, gazebos, screen enclosures, looks like I missed some commas there, tennis courts, and other accessory buildings. And then subsection to that is the setback. So we talked about you could increase the setback. The setback from the water's ordinary high water elevation for single-family duplex buildings and other accessory structures on those properties, other than boathouses, docks, water gazebos, shall be the average established by the adjacent waterfront properties within 200 feet of the subject property or 50, whichever is greater. And it continues to go on to say that P&Z has some flexibility in there. So what your staff is saying is that A is more specific than this. And guys, it couldn't be less clear. In fact, it says adjacent waterfront properties. Well, properties don't have a setback, okay? Buildings have a setback from property lines. So the wording itself is quite confusing. What your staff has done in the past is not always clear when you look back through, and we've looked back now through years of staff reports. They usually just make a statement where they've gone back and made the calculation. If no one is challenging the calculation, they certainly didn't explain how they made it. But I trust that they're treating this instance the same way they may have in the past. I think that this instance is just unusual in its effect. So again, I disagree with George's interpretation that this is more specific. If it was more specific, it would say average established by the adjacent waterfront properties, including all accessory structures and those which are non-conforming. That's specific, right? I couldn't stand up here with a straight face and argue that. So my other, so that's our number one objection, is that they're saying they don't have to include non-conforming structures. I believe it's very clear intent. You can't use it as grounds to add other structures. The other one, which nobody seems to understand the second interpretation that we are appealing, but that is, let's just say that you were going to use a particular non-conforming structure or any other structure. What staff has done is they will say, okay, for the lot right next to you, well, that lot's 150 feet wide, but the closest structure on it is 12 feet away from the ordinary. So now I'm going to give this entire 150 feet, linear feet, I'm going to say that it has a 12-foot setback, when in fact, it has several different setbacks on that property. So then when you average it, you're getting very low averages because you're assigning the closest point of a lot, which is not really what average means. And so as a theoretical example, my client's house that is on the lake, it has a non-conforming structure right here that is approximately 12 feet from the lake. So what we're arguing in the first instance is that you don't count this structure. In fact, you'd probably start counting at about 91.5 or 100. There's a structure there. All the way back to the house is 117. But we think that this is probably where you would start that average. The second point is the staff gave this entire linear footage a setback of 12 feet, which would then be, a building that went all the way across here, instead of creating the average on this lot, which is a combination of the 117 and the 12-foot setback. And the reason that this is important is, again, for example, Mr. Bill Roll owns the home that is to the south adjacent to my client. And then there's a home to the south of Mr. Roll's. So if Mr. Roll's neighbor now tears down that home, they'll say, okay, well, Mr. Roll's house is a 93 average. They're going to once again say that this is a 12-foot average. And then they're going to say the property to the north, I believe, is approved to be set back at 55 feet. So now you've moved this entire neighborhood from having setbacks that are generally over 100 feet from the lake. You've now used this one non-conforming structure to move an entire neighborhood within 50 feet of the lake. And that is what our request is for the interpretation, is that first, that non-conforming structures not be counted consistent with the section 5864A1. And then also the second part of that is whether you use non-conforming or not use non-conforming, that you use a true average and not just the closest point to the lake. I'm happy to answer any questions that you all may have.
Questions for Ms. Wilson? Mr. Seidel, you have the floor, sir.
Yep, thank you. Ms. Wilson, on the, I guess, when you talk about the neighbor to the south, we have a method in place where that's going to go to P&Z, and they're going to see if that setback, the way it would be calculated, would be prudent, or they can apply a greater setback to maintain the integrity of the sightlines of the existing house, correct?
You are absolutely right, but the point in the code is staff or someone is supposed to make the initial determination of what the setback should be. And I agree that once that is determined, P&Z can move it further back based on visuals, or P&Z can move it forward for some other reason. I agree. But if we don't know what that starting point is, we have not given planning and zoning good direction for what this section means. Is the intent truly to try to keep homes in the general line that they're in, or is it to move it forward? And the visual part is incredibly discretionary, because what I would say impedes someone visually, there can be a difference of opinion on that, and we want to make sure that there's at least one thing that there isn't a difference of opinion on.
Okay, I guess what I was saying is regardless of the outcome here, P&Z still has the flexibility to say this is the setback line.
They do, and
So it's only, if this comes in and says, well, the setback line has to be different, they can look at it and say, well, we're okay with where it's at.
Absolutely.
So I guess what I'm getting at is I'm being asked to change an ordinance.
I'm not asking you to change an ordinance. No, I'm not asking
You're
you to
asking
change
me to
anything.
approve the appeal for this specific location.
No, I'm not asking you to do
Okay,
that.
let me be clear what you're asking then.
I'm asking you, your staff has interpreted the code that you include non-conforming structures in the average setback calculation. I've pointed out a section in the code that exists, I'm not asking you to add it, it exists, which states that you do not use non-conforming structures when you are determining, I don't want to get it wrong, but when you are for grounds for adding other structures. So I'm not asking you to change anything in your code. You guys might want to change this code and make it real clear so that we're not up here arguing about this, but tonight, that is not what I'm asking you to
Okay,
do.
so it's just simply the interpretation that was
Yes.
used to calculate this.
You
But
got
then you're giving an example of where it's going to have a harmful effect in the future as
'Cause-
part of your appeal. So that's why I'm saying, so you're
I
asking
didn't
us
have
to-
another example to give. If someone else in the
Right.
audience has one. then-
Okay, so so we're really just concerned about today's appeal, and we're
Mm-hmm.
not concerned, okay, thank you.
Yes, we're concerned about the interpretation. Commissioner Sprinkle?
My contention here is that Dan and legal looked at this and made comments about it at the time, because I can't tell you. I think this is gonna get litigated. I have no idea what's gonna happen with it, and I don't want to be in the position of trying to pass judgment on what I think is a pretty funky way it's written. This area, as we all know, does not fit into anybody else's plans. When you go to 12 Oaks, it's not like anywhere else. So all of that has to be taken into consideration. But I believe that was taken into consideration when it first went to the staff and they looked at it. So I'm not willing to overrule what legal gave them the opinion of back then. And I would like us to fix this so that it's very clear in the future.
Commissioner, do you have any comments specifically towards Ms. Wilson? Any questions for her while she's here?
I do not.
Okay, Ms. Cooper, anything specific to Ms. Wilson?
I don't have anything specific, thank you.
Okay,
I didn't
thank you.
speak with Ms. Wilson, by the way.
Yeah, and that's what I realized that after I asked you all if you had spoken, I did have conversations with Ms. Bonifay and Mr. Cohen, and Ms. Wilson offered me the opportunity, but I declined simply because I thought I had enough information. So, thank you, Ms. Wilson. We'll certainly have you back up if there's anything that you need to address. I'd certainly open up the podium to Ms. Bonifay and or whoever else is going to be representing Mr. Cohen here.
Good afternoon, Cecilia Bonifay, an attorney with the Ackerman Law Firm here in town, representing Alan Cohen and Z
Ms.
Properties.
Bonifay, will you just pull the microphone down for
Is
you?
that better?
Yeah, that's
Yeah,
better.
okay, great, thank you. First of all, let me say, I guess that, we're here after 2 full hearings before the Planning and Zoning Commission, your staff making interpretations, planning staff first, Mr. Wigginson being asked because the appeal letter was sent to him. He then made a separate interpretation. Mr. Langley's here with us tonight. He was also the attorney that was at the P&Z, and I think in your minutes it states, they asked specifically, what is your opinion? How do you view this? Are we making the correct interpretation? Again, there are certain statutory principles that operate when we look at state legislation or city codes. And first, Mr. Wiggins has pointed that out, that the general intent is just that. It is a general intent. So Ms. Wilson has sort of bootstrapped her argument by taking out this section. Yes, it's in your zoning code and it's in Article 3. But the whole intent here was to talk about not using non-conforming structures as the basis to allow further non-conforming structures by, and that's when it says, as grounds for adding other structures or to allow prohibited uses. So you couldn't gain from having a non-conforming use and then say, well, I'm going to use that, and because it doesn't meet any setbacks or criteria or anything else, you should let me have a house next door, I'm the owner of both, and then I could sort of like, you know, benefit from the bad act or from the non-conformance. But this was an old 6-car garage for the estate property converted to a gym, probably larger than some people's houses. You saw on Miss Wilson's where, you know, she showed you the layout. There are 4 or 5 structures on this property. Some of the others may be non-conforming. I don't know if they meet all your setbacks and requirements. I think Mr. Wiggins stated at the P&Z that you couldn't have that many today, and some of those others might not be allowed. So I think for one, you know, the statutory says you always, the general is replaced by or guided by the more specific. So in your code, it does go back and you say, when we do in 5887 D5, here are the standards, because these are very special places to you, which gives Winter Park its charm. But that, you know, it's going to go to the Planning and Zoning Commission, and so it looks at what can be used and what can't be used. So in there, it specifically includes like boathouses and gazebos and pools and these other things. If they had meant, or you had meant, or the framers at the time had meant to say, and that means any non-conforming use, it would have been put in with those specified uses that couldn't be counted when you come up with this 200-foot average. It does not say that. So it just says accessory structures. And clearly, this large gym that sits 12 feet from the lake is an accessory structure. And it is not eliminated from your code by being included in this 200-foot average. So again, I think Mr. Wiggins, when you look at whether you agree with him or not, but what he was saying was, look, in non-conforming use, our goal really is not to allow one non-conforming use to result in other non-conforming uses being approved. A big, and this, you know, I was not a math major, but a big thing you heard today is about average. Oh my gosh, we don't define average in the code. So I asked one of my staff today to go to Wikipedia or wherever and start, you know, what does average mean? And I think Ms. Wilson kind of got in trouble with this line of questioning at the P&Z when several said, well, wait a minute, you don't mean the mean or the average. What you're talking about is really a weighted average. And clearly, your code nowhere says we're going to use a weighted average. And that is very different than an average, because according to my staff, average is a single value, such as a mean, mode, or median, and it represents the significance of all the unequal values. Mean is defined a middle point between the extremes. And boy, that's what you had here. You had 12 feet, then maybe you had 95 feet, maybe you had 100 feet. So what she's trying to do is do a weighted average by saying, okay, first of all, let's throw out non-conforming use, so scratch that one off the list. So we get rid of the 12 feet. And then, because the house, which is very large, and my client actually built and lived in for many years, occupies the greatest amount of frontage on the lakefront, we're going to give it a really high average. And then those other little structures that you saw, well, not so much. We're going to maybe weight them much differently. Well, if you start doing a weighted average mathematically, you're going to come up with a very, very different number than when you take the average or the mean. And I think clearly, whether you go to Webster's or Wikipedia, what your code says is average, and average means mean, and it means taking all of those values and coming up with, you know, what's the average of those. It does not mean coming up with an entirely new process that, to my knowledge, the city has never used with this weighted average. If you want to get rid of, make your code specific and get rid of non-conforming uses and say they can't count in this calculation, so Mr. Roll won't be worried, or Mr. Clayton or others of the other 12 Oaks residents, then I think prospectively you should do that. But I do not think at this point, because what you will do, and this was, I think, a way that Ms. Wilson approached this, if you overturn the staff's recommendation today, they will take that as a negative action by this board, and they will then bootstrap that argument into their writ of certiorari, which is pending as a civil lawsuit in circuit court to overturn your planning and zoning commissioner's recommendation. So, and again, we already talked about that. That's not the issue today. I'm just telling you that an opinion today on this just interpretation will and can be used to buttress their position that the P&Z should be overturned.
Thank you. Any questions specific to Ms. Bonifay? Mr. Seidel?
Ms. Bonifay, do you have the layout that you showed me that you could put up on the screen that we could see that what we're talking about with the setbacks and the houses?
Oh, the one that Ms. Wilson had used?
The one that shows your proposed structure.
Yes, and I don't know that, let me ask Mr. Cohen, because I didn't bring that with me. You mean on his particular lot, exactly where his structure is?
No, I just wanted to see I had asked Randy to forward the PowerPoint to y'all. Did you guys see the PowerPoint to see what we were talking about?
Yeah.
No.
No, this is what was
PowerPoint.
originally used, and I'm sorry, Ms. Swaywood, when we looked at that with you, and I think this was the original PowerPoint that staff did, which showed the mean ordinary high water line, and then showed
Yeah.
sort of where the line would be and what the alignment would be. Let me look.
Yeah, no, that's fine. If you didn't have it handy, that's something I thought that the rest of us should have a look at, so we understood today what we were discussing.
I have a quick question while you're looking for that from legal, if you don't mind. I understand that they have filed in circuit court. You have asked to have that not accepted, is that correct?
The city has filed a motion to dismiss on the basis that the appellant failed to produce a record,
This is what
an
he's
adequate
referring
record
to
of the
that
Planning
was
and
in the
Zoning Board
cities.
Okay.
Commission, but
So as our attorney, would you recommend that we table this until, I mean, I don't know what the urgency is that we make our decision. If indeed Mrs. Bonifay is right, I have been told that they cannot use what we say on this board
Yeah.
to impact this lawsuit. So if they can, perhaps we should not be doing this right now. Perhaps we should table it and come back and talk about our code after they finish arguing about their setbacks.
yeah, I don't make that recommendation. We do have a process for appealing interpretations of the building and zoning official. We've already gone through part of that process through the Planning and Zoning Board. This is the next step.
I understand it, but we have the authority to table things, and my question to you is, should we?
Yeah, I'm not recommending that.
That's another question for
I'm not recommending that. We have a process. We're here. We've had testimony and argument. I will say that regardless of the intent of the appellant to use or not use the decision today in the lawsuit, it's my opinion that it's not appropriate. And the reason for that is that the petition for writ of certiorari in the circuit court is, by the rules of civil procedure, restricted to the record that appeared before the Planning and Zoning Board. Obviously, this is 2 months after the fact. So I don't think it would be appropriate. Now, I can't tell you that they're not going to try, but I think that was Ms. Bonifay's point.
Thank you.
But the
Anything in the public
rules
record can certainly
don't
be
allow
used.
it. Thank you.
Mr. Seidel, you still have the floor, sir.
And Mr. Seidel, I think this is the shot that you had shown me,
Yeah, no,
which is in the,
that's the exhibit.
sorry, it was in my notebook, but it was, I think this was part of the original staff recommendation to the P&Z at their first hearing.
Okay, so the structure that's on the right side of the sheet as we're looking at is the proposed structure. The structure on the left side is the existing structure, correct? Okay, okay, thank you.
Okay, Ms. Sprinkle, any questions for Ms. Bonifay?
No, sir.
Ms. Cooper?
No, thank you.
Okay, the one question I have for you, Ms. Bonifay, before you depart, I know that there was a previous structure that was, I think, approved by the parties. As I understand, it was a two-story structure.
Correct.
Was that set back further?
I think that in that case, it may have been, it was a totally different layout,
Right.
and that it was 2 stories, in my
But
understanding.
we're discussing the setback,
Right, right, that it
So-
had a pool, so I am not sure what that setback was, but the setback maybe to the main house may have been
A little bit
a
further,
little bit further.
but the pool
And
may
that
not
was,
have.
right, but the pool went, I forget how many feet, 18 feet or 20
Okay.
feet, so.
Thank you.
And do we know the setback on the pre-existing home that was torn down?
Yes, and, wait,
It was 1,000 square feet. It was the original servants' quarters for the original estate.
Mr. Cohen, if you're going to
No,
speak, would
you're
you
gonna
mind
have to-
stepping
you're
forward
gonna
to the
have to
microphone
come
and
up.
just saying your name and your address for the record, please?
Right. Now, this is your proposed structure, and that's what that is showing with the 55.6. All right, and let me turn that in. Thank you.
Okay, thank you. We'll have you back up if there's questions that we need to. Okay,
Well, I'm
folks.
sorry, Steve, I didn't get an answer.
I'm
My
sorry.
question was, what was the house that was demolished? What was the setback from the lake?
On that, I am not sure, and only Mr. Cohen, I don't know if you measured that or not, but he can address that when he comes up. I'm sorry, Ms. Cooper.
And I want to make sure, now that you put this drawing up here, that I understand. So the main residence that's next door to you, what is their setback from the principal residence? From the closest
Now, wait a
point to the
minute.
lake of the
All right,
principal?
and I think that, and I don't have that staff calculation, I think it's
That may be
probably
a staff
100 feet.
question.
Yeah.
That may be a staff question. Thank you.
Okay,
There,
okay, hang on one sec. Do you have a question for Ms. Bonifay?
well,
Otherwise, we're gonna.
there is an overhead picture that shows the roof line of both of these homes online somewhere, because I saw it before it was torn down, so that it can show you where it was.
Okay, if someone needs that, staff can grab that if that's a request from the dais. Otherwise, we'll have you back, Ms. Bonifay, if,
All right,
once
let me look at that.
we hear.
All right.
Okay, folks, before I open up the floor to public comment, I'd like a motion. So we can certainly have discussion, but we're not going to hear from the public until we have a motion, so the public knows what to react to. So and let's just have discussion first before, I'm not calling for a motion yet, but let's have discussion. Ms. Cooper?
Can you put up my charts? And I want you to know that I put this together just because I wanted it to be easy for me to talk through quickly. I took my job here as to look at our codes and determine what our code said. And so that's how I approach this. I am accepting of your decision that we cannot overturn or consider the original decision, but there are issues with the code that I do see. The first one is that I support the appellant's position, and I want you all to know I did not speak with Ms. Wilson. I'm on my last term as a commissioner, and I would say I've been listening to her too long, because you're going to find a great deal of similarity here, and I did not speak with her. That was not the point. I just looked at the code.
That's actually scary for both.
I know. We've argued many times, but when I look at 5864A, I do believe it restricts the use of non-conforming structures in the calculations. The second thing is I do not support the building official's position that 5887D5A includes accessory structures in the calculation of lakefront setbacks. And this is simply based on an interpretation of the words of the code. I requested from staff a list of actual decisions by the staff, and they did not have that available, so I was not able to go look at customary practices, only what does the code say. And number 3, I do not support the appellant's position that 5887 requires the average lakeback setback calculation to include the averages of setbacks for the width of the entire lot. Whether it should or should not, we can talk about later, but I don't believe it does now. And additionally, I personally would like to see us direct staff to come back to us. I'm not comfortable saying we're not going to change the code. There's too much ambiguity in the code and we need to fix it. The next page, please. I want to give you my rationale for what I have recommended. Patrick, can you give me the next page? I'm sorry. Did you go ahead, Wayne? Can you go, the second page, is that at the second page? It'll have a number on it. Number 2 is what we need. Okay, these are the things that I think staff needs to take a look at. I'm not saying I think they need to be changed to these exact words, but I do believe that there's ambiguity enough that we need to consider this. I would like the P&Z determination to clearly come to the City Commission for appeal in these situations, not the Circuit Court. I would like to clarify the definition section that average, thank you Cecilia, is the mathematical mean. I would like to clarify the definition of setback to state very clearly that it's the minimum horizontal distance from any point on the building to the property line. I would like to clarify that non-conforming structures are not included in the calculation of lakefront setbacks for principal residents. I would like to clarify that accessory structures should not be included in the calculation of lakefront setbacks for principal residents, or that we use the weighted average approach. We cannot be placing principal residences that can be 10,000 square feet based on a 1,000 square foot accessory building. That doesn't make sense. That is not consistent with our comprehensive plan policy of protecting our lakefronts. I would also like to clarify and restrict unduly impairing lakefront views by way of landscape screens. The next page, please. Now the rationale for my thoughts, and I'm hoping that I can get some support.
Motion here, I'd like to get back to the issue at hand,
I-
not some of the thoughts moving forward with the
This is
code.
absolutely the issue at hand. My
Okay.
job and your job is to evaluate whether the code was interpreted properly.
That's correct.
That's what I'm doing. Okay, so I support the appellant's position that the phrase "nor be used as grounds for adding other structures" is nowhere defined in the article, and the only thing you can do in that situation is to ask what is a reasonable application of that. So for me, that says that you should not use non-conforming structures for calculating the placement of other structures within the district. So I would absolutely agree with her interpretation of that. Because if it doesn't mean that, what does it mean? The last part of this phrase already says that we cannot create situations where we are creating a use that's prohibited. And that is what George brought up, and I 100% agree with that. We cannot have setbacks that are less than 50 feet. So then the question becomes, this phrase is not defined through further reading of the article, so I believe that's a reasonable interpretation. Next page, please. The appellant, that means interprets, not interprets, whatever that is. There's no spell check, obviously, excuse me. The appellant interprets 5887 to require the average setback to be the calculation of average setbacks for the width of the lot. I do not support that. I believe the definition is very clear that the setback is based on the minimum of the horizontal distance, so that's one measurement. Next page, please, page 5. This one is a little more tricky and will take a lot of staff thought, I think, Bronx, to help us get this right. But right now, if you really read the words of 5887 D5A, the building official stated that the city code provides for a measurement of the average existing structure and accessory structures within 200 feet of the subject property. He goes on to say that it does not state to exclude from such calculation non-conforming structures. And I do not support that the code says that accessory structures should be included in the calculation, and we'll take a look a minute at the words and I'll show you that. The interpretation also states that that 5887 D5A does not specifically exclude non-conforming structures. I believe that it doesn't need to specifically exclude it because that's already been established by 5864, and I do not believe that restatement is necessary. I don't see a need for one of these codes to be subordinate to another because they are not in conflict. And that's when you come into the play where you say that one's subordinate to the other. There is no conflict here. The last one, section 5887 D5A, does not specifically include accessory structures in the calculation of average, and that's what I would like to show you. Last page. I'm all done then. Section 5887 D5A, this is what it actually says. The first thing it does is it establishes who is going to have to comply with this setback. And it says that this setback is established for single-family homes, duplex buildings, and accessory structures. So that shows that on lakefront property, the setback that's established applies to all of these, and that P&Z can change it to 50 feet, but it applies to all three of these: accessory, duplex, single family. It also goes on to say, how do you calculate the average? Excuse me. How do you calculate the average? Can you put that back up, please? And it says that you calculate the average, thank you, established by the adjacent waterfront properties. No place does it define those terms. It's very ambiguous. So the only thing you can do is read further in the code to try to find what that means. And when you read further in the code, you find a lot of examples right in the lakefront property setback that tell you what that means. And it says for single family and duplex structures, the next page, please. It tells you that in the lakefront property, R1 AAA, it discusses the average setback for front yards of lakefront properties.
Commissioner, can I just interrupt for one moment? I'm just trying to, how much more time do you need?
I need 2 minutes.
Okay, thank you.
The front setback shall be measured to the front vertical wall of the house. It doesn't say to a building, to a structure. It measures it to the house. The house is the principal residence. That makes infinite wisdom because we do not want all of our lakefront homes moving closer to the lake based on accessory structures. So however we end up moving forward with this, I would like to see us clarify those ambiguities. And from my personal time on P&Z, I do not recall using accessory structures to establish principal residence setbacks, nor do I recall non-conforming structures. But I've been advised by staff that non-conforming structures have been used consistently over the years. I have not yet seen that list. So for me, I'm just looking at the words of the code. And words of the code to me say non-conforming structures, not in the calculation. Accessory structures, not in the calculation, and we measure the average based on the average of each individual lot from the house to the lake. And if we need to fix those things, we need to fix them, but that's what I see in the code. So I support you relative to not including non-conforming structures. And I would go further to say we should not include accessory structures. That's it.
Okay, after that, do you have a motion?
I do.
Okay. I'm happy to take a motion now, if it will guide the discussion up here.
If I could have a follow-up, 2 minutes, then I'd
I'd-
probably make a motion.
2 minutes?
2 minutes, Mr. Mayor.
Okay.
So, I first want to say,
Mr. Seidel.
Commissioner Cooper, I appreciate the time you spend on this and going through these in great detail. As a person who's involved in a business where we can get into great detail, sometimes the ambiguity, am I saying that right? Thank you. It's been a long couple of weeks for me. Anyway, right, and so I can give you an example where what you said could just really we'd be having the opposite argument on a very deep lot where someone has an accessory structure up front and we're telling them they have to build their house 300 feet from a lake because they're on a 500-foot lot. So things can work both ways. But what I do like is the fact that we have a process, and that's the planning and zoning, to go through where reasonable people can debate and discuss what the setback for a house should be. And I believe we just went through this process on the Lake Killarney redevelopment program where there was the same issues and what structures count, which ones don't. And I believe those got negotiated out by the attorney and the property owner to a thing where everyone was agreeable that this is what could be done at that location. And that's what I'm more for us as a city working that way than I am as a city going back and trying to, we will never get our codes 100% tight and make everybody happy. But we do need to correct some things and get some things corrected. So there's a few of those that I'm happy to go through. I don't think this is the place to do that and have some discussion of what we can do on those. So for me, there was a P&Z meeting on this, and there were discussions for the setback. And the setback ended up where the setback was, and I'm okay with that. We've got that process. So when it comes to me, I'm happy to make the motion, if I can, Mr. Mayor.
I'll take a motion from anybody right now.
Okay, I said 2 minutes, that was right. That we do not approve the appeal. So I don't know exactly how the wording is here.
So you either, if you'd like, you can make a motion to uphold the
P&Z,
interpretation.
I would make the motion to uphold the P&Z interpretation.
Okay,
And
staff interpretation.
And the staff interpretation, which I will tell you, I've been through the staff when I built my house.
Mr. Seidel, if you'd hold on 1 second, I'll
They
just
do
look for a second
excellent
since you
job.
have a motion floating. So I'll look for a second on that motion.
And I'll second it.
Okay, now Mr. Seidel, if you'd like to continue.
Yeah, thank you, Mr. Mayor. It's just that our staff is very aware of the codes, and a lot of the things they do, they have done, and that's all brought up at these meetings. This is how we've been doing it. So if we need to kind of codify how we've been doing it, I don't think we change how we've been doing it, because I think, we've only had this come to us a couple of times. There's a few items that only come to us once or twice, and in my mind, that means the code is working. So it's then we can deal with those exceptions one at a time. So I would like to get some of those items you brought up codified, that this is how we've been doing it, and just continue to do it that way.
Ms. Franks?
For sure, I'd like to see it fixed if it's possible for the future. I would agree with you that so many of these, especially at 12 Oaks, are not going to ever fit because that alone is a very different lot in a very different area. So the reason I'm not dealing with anything about the houses, I'm strictly dealing with the process, and I would at this point support the process because it is going to the circuit court, and the circuit court, I agree with you, Carolyn, I do think we should not require people to have to go to court and spend all that money to do that, and it should come back to us, but that's not why we're here. We're here now to decide whether or not the process that was used we can support, and I would support it.
Mr. Weaver has recused himself. I'd certainly offer him the opportunity to comment if you'd like, Mr. Weaver.
I don't have any comment. Thank you for the
Okay.
offer.
Certainly. So I would simply say that this is not as straightforward possibly as it should be, and things can be interpreted different ways. We do have a process in place. We have, Ms. Cooper, I think you brought up some interesting perspective. Mr. Seidel and Ms. Sprinkle, I agree with your perspective on this as well. So I can support moving the interpretation as presented. This would probably go to court one way or the other. So with that, we will open up the floor to public comment. As it stands, a motion on the floor to approve the interpretation as presented by staff. So let's open up the floor to public comment. Anybody wishing to address the commission on this item? Now's your time. Okay, Mr. Roll. That's a pretty dramatic pause there, Mr. Roll.
Well, I thought Dr. Cohen was going to speak.
be fairly comfortable right now.
Okay.
So,
My attorney told me that.
yeah. Hey, yeah. My name is Bill Roll. I live next door at 1194 North Park Avenue. And in the early 2000s, I had the opportunity and honor to serve on P&Z. And because this will affect me personally, directly, perhaps negatively in the future, I just wanted to know, you guys to know what my feelings and how I look at this is. Now, Dr. Cohen certainly has every right to build whatever he can get on his lot. It is a tight lot. He knows it, and he's trying to build a house that he can comfortably live in, and I have no qualms with that at all. And I also will tell you that staff here is above good. They're superior, and I've known George and Jeff and Randy and most of you guys for 30 years or more, and I respect everything that they do. Staff sometimes gets things wrong, and that's why P&Z is there to watch them, and then you all are there as our elected officials. In this particular case, the use of this particular building, which is non-conforming, greatly affects the setbacks. As you can see, Dr. Cohen's original house was probably going to be between 85 and 90 feet off the lake, depending on where the lake is. I don't know what the exact number was. And that would have been, he can still build a house there. Now, on my side, now that we've introduced this as an acceptable 12 feet of setback, instead of using Paul's house at 95 and mine at 92, the person that buys my next door neighbor is going to be averaged all the way down to close to 60 feet. I have no confidence in P&Z to protect me once that happens because of sightline loss. So I'm going to lose sight. They're going to move all the way into front of me and take out 40% of what I can see on the lake going around Park Avenue. And this is what the unintended consequences are of a decision like this. I never heard of a thing. We've never used a non-conforming. If George says they've used it before, it was after my time, before my time. I never recognized it. I don't remember using it whenever I had my application in that. That building was there. So, and it's very concerning that we are just going to adjust this average by such a huge extent. There's another structure that sits on top of a boathouse. Are y'all going to say that's a zero? Count it as a zero? I mean, this is just, this could go, we could be pushing houses all the way up to the 50-foot line, all up and down our lakes, and I'm not so sure that that's what you want to do. P&Z certainly didn't step up in this case. I don't agree with George in this, and I'm just, I wish you would vote no.
Okay, folks, anybody else? We're going to close the floor to public comment.
I'd like to make an amendment.
Excuse me, Commissioner. I would certainly like to offer either of the parties the opportunity to come back up to the podium before we do that.
I just wanted to
Thank you, Ms. Wilson.
make one very quick point. Can you turn? Yeah, there were just some questions about that. Just one thing as to process, and that is, just two clarifications. One, when I originally made this argument at Planning and Zoning, Dan, I think it's fair that you said I had a reasonable argument and it was up to P&Z to make that interpretation. So I don't want to leave, it is not as if this interpretation came from your attorney, Dan, and now I'm asking that it be overturned. Part of the process was P&Z made that interpretation, and I think you said it was reasonable to go either way. And second, that this is part of your process. I'm not asking that the process be upended, Commissioner Sprinkle. I'm asking that you use your process, and if you agree with some of the points that that I made or Commissioner Cooper made, this is the time in which we can address those. And just to answer the question, since they didn't seem to have the answer, the home that was previously approved but not built to the north of my client was set back 68 feet. The home that was demolished was over 100 feet back.
Thank you. Okay, Mr. Cohen. And then we'll move back to the dais. Mr. Cohen,
My name
you
is
have
Alan
the floor,
Cohen, 1204 North Park Avenue. I've been a resident of Winter Park for 30 years. To Ms. Wilson's point, the home that was originally there and that was demolished were the servants' quarters. I'm not sure I would call it a home. It had no kitchen. It had 3 separate rooms, and it had a patio. My wife and I tried to live in it for a season, and it was just too small. And then when we started looking into adding a kitchen and doing other things, it just became overwhelming, and the easiest thing to do was to demolish it and redesign a house. That was 1. 2, the house that she refers to that was previously approved. When I was selling the property, I was hoping to sell it as a single property because it's such a unique piece of property and it was so special to me. And they're really 2 contiguous deeded lots next to each other that were never legally changed or integrated, although they were integrated in terms of the backyard. When I was trying to sell it, it was clear to me that if I sold one without the other, that the other one's value was going to be limited or was going to be potentially limited. And as a result, I made that one of the conditions of selling the house. So when Mr. Missigman wanted to buy the larger house, he knew that I had to simultaneously sell the smaller lot. And just coincidentally, the builder that I was working with, Zane Williams, was able to find a family that he had been working with who was looking for a lakefront lot, and he brought them, and at our expense, we designed a home for that lot. We could show you the lot, I could show you the home design, the whole deal. I have it in my records as a 50-foot setback. Ms. Wilson said a 68-foot setback. I suppose that does not include the pool, so that would be the difference. It's a 2-story house. It would effectively, in terms of optical sight lines and geometry, block more of that view because it would be 2 stories out of that corner, 15 foot forward, rather than less. But more importantly, the owner or the potential buyer backed out. And that was the reason that house wasn't being built. There was no promise, there was no implied promise, there was no contingency on Mr. Missigman's contract. It was very clear that that was going to be sold and that he, if he wanted to, should and could buy the smaller lot to protect his interests. He chose not to. Repeatedly that came up. Mr. Wetnight is here, Mr. Knight is here, Mr. Pinnell is here. They could speak to that discussion with his real estate agent. I urged many people that had looked at the lot to please buy both because I wanted it to stay together. That was an individual decision. The idea that whatever was going to be built on that lot was not going to intrude in any way, shape, or form on someone else's house is ridiculous. Nobody would think that. And there are other factors to include here. For one thing, the large house sits almost 10 feet higher than everything else. It's Mount Olympus looking down on its subjects.
Mr. Cohen, I'm sorry.
Yeah.
Are there any comments you have specific to any of the comments that came
No,
into the
those-
public section?
That's it.
Thank you, sir.
Okay.
Appreciate it. Ms. Bonifay, you owe me one. I'm joking. That was a joke. Okay. I cut it. I just said I meant I cut him off a little early for you. Thank you, Ms. Cooper. I'm going to turn the. You did ask. For
I
the
did want to
floor.
make just one motion. The appellant addressed many things in her letter and George's interpretation, and I understand that you have moved to accept the P&Z. I would like to request that we accept the P&Z decision on this interpretation with one caveat, and that is that we not include non-conforming or accessory structures in the lakefront setback calculation for principal residence.
If I may, I think given the motion, that would be
That's in
inconsistent
conflict.
with the main motion and would actually contradict
That's
its
correct.
purpose. So
That's correct.
I think there needs to be a vote on the.
So you're saying we have to accept every one of the aspects of the decision? We can't take exception to one?
No, I'm not saying that at all. What I'm saying is that you have a main motion pending that accepts the staff's interpretation as upheld by the Planning and Zoning Board, and the motion that you're making to amend that sort
Is
of
in conflict.
contradicts the main point of the motion. So it's a procedural thing. If the commission goes along with you, I'm okay
So
with
why
it.
don't I handle that as the procedure here? That is in conflict with the main motion, Commissioner, so the chair's not going to accept that amendment.
All right.
Okay. Mr. Seidel? I'm
Thank
sorry,
you, Mr.
Commissioner, you still have the floor if you'd like it.
No, I'd just like to see the panel make a motion that would keep us from continuing to move properties closer to our lakefront.
I'm certainly
which is
happy to
what we're
have
doing,
that
and I'm trying
conversation.
to figure out how I can make the motion to pull out
Yeah.
something out of this so that that isn't the result of our decision, because that will be the result of our decision.
So, Mr. Seidel, you have the floor, sir. And then
Yeah.
we're going to move this to a vote. Thank you.
I do have a question, and I don't know if George is the correct one to answer, but the photo that's on the screen, okay? This is what I'm looking at. I'm looking at the line that goes across what I would call the edge of the infinity pool on the large house. And that line goes, if you extend that line to the right, it appears to be where the front of the new dwelling structure is proposed, correct?
Right, that's correct.
Is that, so the new dwelling structure is not gonna go past where that pool is? Is
That's
that
correct.
correct?
Let's keep in mind, folks, the motion is on the interpretation of the
Correct.
staff. So let's stay focused on that. Okay?
Understand.
I think
but
there's
I-
plenty of discussions we can have
Okay.
about this
Right.
moving to Commissioner Cooper's perspective. We can have further discussions about how we want to handle the code, but tonight we're here voting on the interpretation of that staff and that legal is confirmed. Okay?
Understood.
Thank you.
Thank you.
Okay.
And my point is that we have to interpret what's there now, not what we wish was there now.
That's correct.
And not what we want to change it to become. So we have to vote on what is there now. And then, at the same time, to speak to Mr. Roll's concern and to Commissioner Cooper's concern, I don't think anybody up here wants to move, homes closer to the lake, but we have to do that after we are concerned with what has already happened. And that's what we're dealing with, and that's it today.
Okay, folks.
We're not voting on the decision made by P&Z on this property setback.
We're voting on
What we are voting
interpretation.
on is, do we believe that the code says that accessory structures and non-conforming structures should be calculated in our lakefront setbacks? That's what we're saying. And what's going to happen, that mathematically will cause structures to start being principal residence, not just accessory structures. It will cause them to start being, over time, closer to the lake. It will, and that's
So-
why.
I think we
so
need to
hang
look
on,
at a
folks.
different way
Hold
to
on,
address
folks.
that than
Please,
this.
please. We've kind of gone around and around. I've also sat on this commission, I've sat on this dais when we talked about closing down the sidewalk in the street between Hannibal's and Armando's was going to lead to Mardi Gras in the streets of Winter Park. So there have been interpretations of decisions that are made up here. We've already said, I think unanimously, that there's discussions that need to happen in the future to address some of the what seem to be inconsistencies in the code. So that's time and place, that's another time and place. Tonight we have a motion, we have a second to uphold the interpretation by staff. And Cindy, if you would please read the roll on that.
Mr. Mayor, let's just be clear what we're voting and how we're voting.
We're voting to uphold the interpretation that staff the staff and P&Z and city attorneys have supported.
Thank you.
Cindy, please, the roll.
Commissioner Seidel?
Yes.
Commissioner Sprinkle?
Yes.
Commissioner Cooper?
No?
Commissioner Weaver, conflict. Mayor Leary?
Yes, thank you. Good luck, guys. I know this is not over and done with, but I appreciate all of you for taking the time and the passion to do this. I know each of you, and we wish you well. Okay, folks, one thing that I did, that I forgot to do earlier was, Commissioner Cooper, you were kind enough to ask me to serve as a delegate at the League of Cities. I'm going to be in conflicting meetings with the League of Mayors, Executive Board, and some other conflicts. So, Commissioner Sprinkle, I know you are going to be out there. I would ask if you could serve in that capacity.
I'd be happy to.
I think we just have to have nods. Is that okay? I didn't even know you were back. I thought you were. Is that fine? Is that okay? So I think we have 3 nods. Randy, is that okay? Yes. Okay, great. And with that, Mr. Seidel, you have a commission report. Oh, I apologize. Folks, we're going to open up the floor to public comment. Anybody wishing to address the commission on anything that was not on the agenda, now is your time. Hello, Sabrina.
Hello, Sabrina Burnett, Assistant Director at the Winter Park Public
The
Library.
Taylor of Panama.
What's that? Oh, I come only in celebration. I just wanted to say thank you all for your support of our summer reading challenge and to congratulate our community on reading over 10,000 books. Yay, we're so excited. We read 10,440 books, so we went over that limit, not even a small amount. As you know, it was our challenge to combat summer reading loss and provide learning for all ages in our community all summer long. It was a 35% increase over last year's numbers, so we were really excited to see that too. And it just proves once again that we are a great literate community. Thanks.
Thank you. Sabrina, there was also a wonderful article in the New York Times. I don't know if you've seen it.
Yes.
And I don't know if Clarissa, you had seen it about libraries and just some of the wonderful things going on in the libraries, but it's worth sharing on your site if you haven't done that already.
We have it in our queue.
Oh, it's great. It's a
Hey,
great
would you
article.
also tell them about the back-to-school kindergarten event you
yeah.
all had? Because I was there and you had a
Yes,
bunch of
Commissioner
little ones.
Sprinkle, you were there. So this is the second year that we've done a Step Up to Kindergarten event for families. It's a great way to alleviate some of that back-to-school anxiety about getting on your first school bus. So we work with OCPS and we get a bus to the library and the little ones get to get on and hear from the bus monitor the rules for the bus and parents can ride with them. Great photo opportunities so there's not as many tears on the first day and they take a swing around the block and come back to the library. And they do get a pack of back-to-school books as well.
Thank you. Okay, Mr. Seidel, you have the floor, sir.
Okay, I have a few items tonight, Mr. Mayor, but I'll be brief with all my items. I did have my coffee talk last week on Thursday morning, and a couple things came up that we had talked, or one came up that we had talked about previously. I just kind of wanted to get the status for everybody, but it was about the fiber optic network in the city and kind of what the status of that is. And I know we were working on the one line to go down Aloma. It's budget time. I really had kind of lost track of what was going on, so that's why I'm asking now.
Update on that, Randy? I asked them the other day.
So this should be a fresh update.
Sure, there's two items. So one, we continue to install the conduit and the fiber for the backbone, and we're still trying to complete that final leg between Station 62 and City Hall. Been working to try to get permission to go under the CSX. Secondly, we've put out an it was an RFP, it got another different initials for it, but a request for interest, if you will, from all providers of fiber, and we've been working with a company to look at, partnering with them to move faster on getting fiber throughout the community. So we're in negotiations with them now on a contract we'd bring back to the City Commission for consideration. So I'm hoping within the next 6 weeks that contract will get finally negotiated and into the commission for approval.
So the big spool, the giant spool, is that what we are burying, or what is that?
I don't know what the giant spool is, but
Come down to my house and I'll show it to you.
So there's two
Winter
different.
Park's newest attraction.
So not all of
biggest school.
So not all of the fiber going in the ground is the city of Winter Park. Tico's out there doing gas, but they're level 3 is out there putting fiber, throughout, I should say through the community. So there are several companies putting in fiber. So they're not all us, and they have the right to do that in the right of
So,
way.
Randy, when you say they're putting in fiber, is that for our residents, or is that just pass-through?
It's private, so.
Yeah, yes, it's private, so it's level. Yeah, level 3 basically acts as a highway for others on
Okay.
fiber.
Okay.
And so they're putting it in, yes, for customers, but their customer may be other utilities ultimately.
Yeah, but they're putting it in our city property, okay? I know that, but because I live on a dead-end street, they park it down there and they bring everybody down there. I still don't know what they're doing, and I feel like an idiot because I should know something, sitting up here, of what's going in, and I don't have a clue on it. And so I just want us to get a handle on who's putting what where and when, and that is a big frustration to me right now. And I'm sure I'm not the only one, but I know I'm impacted more because they park it down there.
I would offer if there's specifics, because Tico is going through my neighborhood for 3 weeks, shutting down roads, sidewalks. So I just called the city and said, who's in the neighborhood, because neighbors were asking me, and they've told me Tico, and I told neighbors Tico. So just check with the city. They'll
Yeah,
tell
but
you.
we make our rules that say, hey, when we're gonna do this, we let people know, and I guess we can't make those for other people coming into our town, but it's just like anything else. If you tell people what's going on, they are very accepting and open. We just need to somehow or another let people know that they need to hang a door knocker and let people know what's going on. That's it.
Yep.
Mr. Seidel, you still have the floor, sir.
Yep, no, thank you. That item went a little longer than I thought, Mr. Mayor. I'll try to go through the others here. But it is good. I thought that was good conversation, and I now have an excellent answer next time someone asks me. This other topic came up about maintaining the right-of-way trees. And I wasn't involved when that first came up, but now that kind of the recession was over and we have this tree management in place, my response was that, well, we're looking at the tree program now, so this would be a good time for us to look at it. And so on top of that, the other item I want to talk about was home rule on the trees. And I had mentioned I'd spoken with some attorneys when I was at one of my conferences. And what they had talked about was there was a gun law that was just overturned, that the local levels were allowed to do something with guns. Okay, well, my point, and the point the attorney made was that may be an avenue where we can approach this tree item. And so, but I thought it's, us wanting local control, we got 3 heroes here on the commission and the city manager, I think it's worth us investigating what can be done about that statute that was passed, taking control of our trees away from us. And so I would like the commission to have our legal counsel, and I don't know if that's at League of Cities, what's the appropriate forum, but I just don't like the fact that, this was done, but was there a legal avenue? Because I don't feel we can update our tree ordinance until we know and fully understand how this law works. And so I would like us to be are there aspects of it we can challenge?
Well, just say, Drew was here, and I know as she and Michelle and the entire team were working through the tree ordinance, they're very aware of the current the ordinance that was passed, legislation that was passed. So that is going to be part of their recommendation moving forward. Can we fight it? The best place to start is with our lobbyist. He can tell you what avenues there may be some opportunities for.
Okay, well, I just don't like to hear that there is no avenue. So that's what I'm concerned about.
Mr. Lang.
I actually received an email not too long ago and a listserv where some city attorneys in South Florida actually have a pending case in court somewhere down in South Florida on this issue, and they raised the constitutionality of that particular tree statute. So I don't know where it is. It sounded like it's very early in the litigation, but it may be worth.
Give us a little more information on it?
Sure.
Is that something we like to track on the attorney report, like show it on our little agenda here, that the tree? Yeah, so that.
I'm gonna see what I can find out about that lawsuit.
Okay, nope, thank you. Real quick. I just wanted to mention, I heard some comments about the meeting minutes today, and in my profession, we send them out for everyone to give comment before they're finalized. So I think we do a good job with ours of getting them correct, but I'm always willing to listen to some comments and to see if we go ahead and get those in there. The other item that I've talked, a lot about was the gun violence within this country. And since we last met, we've obviously had some tragic events. And what I pointed out at my coffee talk was what we have is we have people on the far right doing certain things and then people on the far left doing certain things. But what we don't have is people saying, when I say doing certain things, they're more saying certain things. They're both defending their position. But neither one of those sides is solving the position. The right, I hear, they blame it on video games. The left, I hear, they blame it on access to guns. I'm okay if we regulate both, because the fact of the matter is, we had someone arrested in the city of Winter Park, okay, that, I don't know how many of you saw that, but that's right here, and that's my daughter. My daughter goes to this high school. And so, as all citizens, we need to start paying attention to what do we do to solve this crisis. This is domestic terrorism. That's what it is. I'm afraid for my daughter to go to school knowing there's people in Winter Park that think this way, okay? We need to fix that as a country and as people. And obviously it does bother me, but it starts with not being afraid to tell people something needs to be done, no matter what side of the argument you're on. And for the people on the left, I would say, let's do something about these video games. For the people on the right, I would say, let's do something about access for these types of guns. And so I hope people hear me. I'd like to see something get done, so thank you.
Thank you, Mr. Strickland. Ms. Sprinkle?
The other thing that I wanted us to mention, a couple of things that are coming up, is we just finished this wonderful summer program. I know that you're going to bring something to us. I just encourage you to bring some kind of report to us about all the kids that were at the community center and all the work that was done there, because I had a chance to see them, and I know that we had a fabulous summer program. We're getting ready to heat Katie Way Pool. That's another big plus, so we're doing a lot of really positive things. We have a lot going on over at Mead Garden again, so I know that they had a program there for kids this summer too. And I would just like for us to put it together and to advertise in some way all the things that we did during the summer for our families. So that's just my little 10 cents, since you're not going to let me get down lower to the ground.
Ms. Cooper?
I'm just happy you're getting rid of the termites. I'm afraid to put anything under the dais. I guess my biggest issue here is like what we had happen tonight. I really don't want to see us just let the codes linger on. They are very ambiguous, and we need to look at and very thoughtfully consider. I don't want to rush. I just want us to be very thoughtful and correct the codes. And I think everybody up here would agree with that. Maybe, I know you like a little ambiguity, and I'm not opposed to a little ambiguity either, by the way, but some things just were glaring in their omission.
Yeah, no, I would concur.
So I just don't want us to move on and let it linger. And we do that a lot, and we do it a lot because we're overcome by so many other things that are going on. So I'm not asking for a quick evaluation. I would like an excellent evaluation. I'd like it to be brought back to us when it's possible. And I don't know, you might want to talk to the attorney. I'm not sure, given the fact that we have a lawsuit going on. In fact, personally, my question would be, why did we have to go through that tonight as opposed to putting that off later? I understand that, but we were told that that 94 didn't actually, we couldn't overturn the decision. So if we couldn't overturn the decision, why did we have to respond immediately? You know, my question is, could we have waited just a little while for that to resolve itself in circuit court before we had to air it on the dais? And maybe there's no way that we can delay reasonable delays, but sometimes it does make sense.
They asked for a hearing, and everybody has the opportunity for a hearing. We could have tabled it at any time.
Right.
But if they ask for a hearing, we give them a hearing.
And do we have a stop clock on that? Because I know some things in the city take years to accomplish, and other things take.
They have so much law to appeal.
I see. They couldn't wait, so we couldn't wait. Okay, well, that makes sense. Maybe we need to look at that, because I think the idea of us discussing an interpretation of our code in the middle of a lawsuit is not the greatest idea, but that's just my thought. Thank you.
Weaver.
Thank you, Mr. Mayor. So repeatedly, we've heard from a couple of neighbors along the Palmer corridor and the Orwin Manor section of Orange Avenue. And as you know, I worked in Southern California for a number of years and went to Laguna Beach quite often. And all the parking for Laguna Beach is on the landward side of Pacific Coast Highway. And they had a number of crosswalks, and like here, it's state law to yield to pedestrians, but what they did, they went one step further, and they had, when a pedestrian would walk up to a curb ready to cross Pacific Coast Highway, there were flashing yellow lights at the road level that delineated the crosswalk, and it was obvious to motorists that they had to stop there, and somebody was coming out. And I do believe that both of these areas of our city would benefit from such a lit sidewalk or crosswalk. And I know there's some pushback for traffic lights and you know, other stop signs and things like that, but I don't believe that either of these would take the kind of effort that it takes to put in a traffic light or whatever. And I'd like to, you know, ask staff to look into that in these two locations.
Where are you talking about, in Orland Manor? I got Palmer.
Along Orange Avenue in Orwin Manor, they, you know, as you know, it's a kind of a drag strip there, and the citizens are looking for some action from the city
Mr.
to
Weaver,
slow the traffic
is
down.
there, I don't believe there's a sidewalk on the eastern side of Orange there, is there? On Orange? I think there's just a sidewalk on the west side,
Well,
right? So what would they be crossing to, the street? I mean,
well, the little park at Westchester where it comes and crosses Orange, I think that's the logical place. It's about halfway down.
yeah, and that doesn't
yeah.
cross over. Brookshire doesn't cross over.
Yeah, I just remind those would have to be done by DOT. It's DOT right
But
away.
I think I mean, he's bringing up the question, which if that's the path, then we talk about it, but
I think it's just crossing from one side to the other. One
pedestrian
neighborhood
or car?
pedestrian. That's been a request in the past, but Commissioner Seidel's correct. I mean, it's a DOT decision. They are actually wrapping up their whole safety study, and they're communicating with Orwin Manor right now.
So when will we see that study?
It doesn't say, because we're waiting to get feedback from Orwin Manor, and that was supposed to happen in July, or June or July, and I'm not sure, I haven't heard from their liaison lately about when they would give DOT feedback.
So why don't, I would offer, Mr. Weaver, that maybe we wait on Orange Avenue, but if you want to move forward to the Palmer, is that okay until we
Yeah,
have
that
the
makes
DOT?
perfect sense. Thank you.
Palmer, we are planning on the flashing.
And then on
RF.
Palmer, I know there's plenty of people who have quietly voiced concerns about flashing lights on Palmer too. Just the visual of flashing lights on, you know, we've taken a lot of time to take down telephone poles because of the beauty of the trees and all that, and we're going to put flashing lights up. So that has been mentioned to me. So I don't. Are you moving forward with actually installing them, or just having the conversation about them?
We were going to install, but it would be the only flashing when it's activated by the pedestrian.
And then how many locations on Palmer?
We're thinking about just the two at Temple Drive and at Alabama. And I did speak with John McMillan about that earlier.
Who's John McMillan?
He's the owner of, well, he owns the house on the Lake Osceola, right over the bridge, and he also owns the Winter Park Pines Golf Course.
Okay.
He was expressing concern about the flashing light, and I did convince him that it would be okay. Plus, he's got a really high hedge there, so.
I wasn't talking about the flashing light getting in anybody's windows, just more the visual of people driving down this beautiful winding street and having flashing lights.
Right.
That was a question for me.
Please be respectful of the historic bridge. Sometime we do things thinking we're making things better, and we
That's
end
kind of my
up
point.
creating clutter and things that are not aesthetically pleasing.
But you're so aesthetic lights.
Signs.
What I'm hearing is to invest in aesthetic lights. That's aesthetic flashers
Well,
that
can I
fit.
also, Mr. Weaver,
Yes,
it's funny you mentioned this
We can
'cause
get anything made or done.
I saw a place down
We
there. I
just
think
want
it
to let
was-
him know to invest in it to make it match the
I think it was
location.
St. Augustine where they have like little flags. So people walk, little holders of flags, when people are walking up the street, they have a flag, and then they put it on the, when they're across the street, they put it in the holder on the other side. I mean, there's ways to get across the street that could be safer without going directly to lights.
They do that in Salt Lake City too, with the flags on each side. I remember coming back and telling you guys about it after I saw it, because it seemed to work there. So there may be other options.
Well, what I was talking about is at road level. These are lights actually embedded in the street. Yeah, so it wouldn't be above the curb level at all, but you can see them, and then they work, yeah.
Is that what you're talking about, Don? Installing?
It could be either or. We haven't purchased any yet.
Okay, so before, can we take a peek at it before? Because I promise you, as soon as lights go in there, we're going to hear from the people who, you've ruined my tranquil little street.
Just a quick question. The ones that are on Katy Way at the trail, is that well accepted, or is there any complaints about them?
It sure stops me if I see them. I mean, it works. That I can tell you it works.
Mr. Weaver, I like where you're going with this, but I think I'd rather have another conversation about it than just say, go ahead and install them, because we don't know what they look like.
Yeah,
No, I was asking for an investigation. I brought it up once before, and I know there's been pushbacks for other types of crossing aids, and I found that one to be less obtrusive, and it's only when a pedestrian's using it would they light up.
So would you put it under the city manager's report to just discuss a little bit, show us some options, just to get a little feedback before we get a lot of feedback?
Yeah, and we can
maybe put it on
to the
future
next
agenda.
Transportation Advisory Board as well.
Great, yeah, let's get their opinion on it before it comes.
Thanks, Don.
I have a question.
Commissioner
Don,
Cooper.
Before he runs away. What are we hearing about the buoys? Has that been pretty positive?
Nothing but positive from my perspective.
Good.
I think they're a lot smaller than we were led to believe.
Right.
I have one person who still wants more, but overall, everybody's happy.
But nobody's complaining about the way they look, or that's good. That's
Haven't
great.
heard it.
Right.
I think
Mr.
they worked.
Weaver, you
Y'all
still
did a
have
great
the floor,
job. How about that? Y'all did a great job.
Yes,
Thank you.
Thank you. So last time we were meeting, we decided not to tear down the Progress Point building yet. And Vice Mayor Seidel had some concerns, or some suggestions, I should say, about maybe beautifying the area. And I want to thank staff for mowing the grass and bush hogging some of the understory brush out of there. And I just wanted to ask the commission, do y'all have any suggestions on what we can do to beautify that area in lieu of tearing the building down? Because, tearing it down doesn't create a less of an eyesore. If you go by the Lee Road property, it's piles of rubble still there. So
I don't have any ideas, but I still don't know why we kept it, because we're not going to use it. So I don't know why we're keeping it. That was a real surprise to me when you made that. I'd like to know what it's going to cost to beautify it, because it's not a usable building as it is now, so why would we keep it?
well, it gives us the option of reusing the building in the future. If we tear it down, then we don't have that option, and it may come to that. We may decide to tear it down, but we still have months to go on the Orange Avenue squad looking into that.
Yeah,
So,
Commissioner, in response to your question, I drove by both properties at Progress Point the other day, and the one hadn't been mowed in, I'm guessing, a month, because the grass was 18 inches high. And so for me, we need to be keeping that private owner, we need to be on them to keep that one looking nice. But if you keep it mowed and weeded and just looking like it's maintained, to me, that's the first thing to do. And then what you do after that, I would leave up to staff.
Okay, thanks. So I have a half an hour to get over to the Maitland City Commission meeting, and Vice Mayor Lowndes is introducing it's a resolution to move the city of Maitland towards better sustainability. So they're going to look at replacing city vehicles with hybrids and electric vehicles, putting solar panels, which we've started to do that here, on city-owned buildings, and so on. And I'll be happy to report back next week on that.
Ask them to work on their water bills while they're at it. That's what I keep getting phone calls about. People want to complain to me about
Mr.
Maitland's
Mayor, I just
water
wanna
bills.
bring up quick, it's quick.
Okay, Mr. Seidel.
Mr. Weaver, just so everybody knows, the FDEP is setting what's called a total maximum daily load for the lake at the north end of Rabidosh. And I know this because one of my friends at the DOT was the only one to protest the TMDL. And they were protesting because the level of treatment they were requiring for the lake really wasn't correct. It was something they were just trying to get this done. So I don't know if Maitland knows about the TMDL, but someone in the Maitland stormwater, when you're up there, you need to ask them if they know what's happening, because it will affect every project that's constructed that drains to that lake. And that includes our Rabidosh development, by the way. So,
And you were aware that that lake gets the whole load from Lake Wilderness, Bell, and Killarney, right?
yes, but those lakes don't have the TMDL. This was the
It
only
happens
one.
when the engineers take over the mics.
Right, but I'm just saying, and I had meant to bring it up here also, because it is important. There's a public comment process, and, you know, the DOT was the only one to publicly comment, because they check all the roads that drain to these TMDLs. And so they were able to make the comment, and one of my friends let me know what was going on. And so anyway.
Are you saying you think that the provisions are excessive, or they're not
It would
adequate
be very
enough?
difficult to meet the proposed maximum daily load for nitrogen and phosphorus in those lakes, and that the lakes don't need to have that load because there's different levels of health that you get with certain levels. So when some of the experts started to look at it for the DOT, they said, wait a minute, this TMDL is way too high for this lake, it can be lower. And so you have to do your reduction calculations and everything else. So anyway. Yep.
Is that lake in Winter Park or in Maitland? It's in Maitland?
Two things. Jim Moy passed, and many of you know Jim. I didn't really know Jim. There is a service for him. I think it was misstated for Saturday. It's the 18th, is that right? There's more information about it. Is I think it was reported as the Winter Park Civic Center, which we all know is incorrect. So, well, it's somewhere else had it as the Civic Center. So it is the community center if people ask. Secondly, for sustainability, one of the things we've been discussing is what to do with our tree farm. You know, I've always been of the opinion, and I think it's been shared by many, that our fields, I'm not sure it makes sense to invest a bunch of money into more fields out there. So what can we do with it? We've talked about a solar commitment. Is there an opportunity to do something out there with solar to help offset our footprint? So I'm not sure what I'm asking, but I would say that we have that property and we continue to just keep it on the...
I think you're asking UAB to investigate. That's
Well,
what
I think it could be used, and I think, you know, again, if we land lease it, or we, maybe there's an opportunity to put some type of low-impact building out there, and I don't know what it would be, but with solar on the top, that we lease the land out to, but I do think we need to come up with what we plan on doing. Randy, was it 12 acres out there?
Roughly, yes.
Roughly 12 acres. It's just been sitting there, and, you know, I don't see the use for a sports facility, but I don't know. If there's appetite to take up to start the conversation as to what to do with it, I'm happy to push that forward. Anybody? Mr. Seidel?
I'd be happy to look at a portion being the solar farm, but I wouldn't want to tie the whole 12 acres up.
What if we zone it so something that can be used, it's low impact, and the roof of that is all solar? I don't know what that would be.
Mr. Mayor,
Mr. Weaver.
are you aware that we use that for hurricane drop?
Yeah, for drop. Well, we
Yeah.
have in the past. We didn't this last time, I don't think, for Matthew, right, Randy? We went right out to Central Compound.
Yeah, we went out to the central compound last time, but we've prepared that site to be our site going forward because we've moved a lot of the we've moved a lot of the electrical undergrounding storage to the compound now, so we had to prepare that site as a potential site for future hurricane debris.
So I appreciate that, but at the same time, using prime 12 acres of property to sit fallow until there's a hurricane that we can dump our debris on sounds like a waste of taxpayers' resources. So I don't know. Just something to think about. From my perspective, what are we going to do with that place? So I don't know.
I would love to see us at least look at that, yes.
Be something. Okay, folks, if nothing else, we are adjourned. Thank you.